This is The Best Defense. I'm Jami Floyd. Amy Krause says she is a victim of aggravated battery after a fight with another woman at Disneyworld, of all places. But is there really enough evidence to prove those charges? For that, we put our prosecutor, Friedman, on the spot. Yesterday, we heard from experts who testified all about the alleged damage inflicted on Krause by Victoria Walker, the defendant in this case, during their Disney World scuffle. But in order to prove aggravated battery, in any case, prosecutors need to prove permanent damage. During cross-examination of neurologist Jeff Friedlander, the defense chipped away at the state's evidence supporting Krause's medical claims.
The optic nerve, the only thing I could do with the equipment I had was look for an afferent pupillary defect, and she did not have one, meaning there is no severe damage to the optic nerve, which is one of the nerves responsible for, it is the nerve responsible for vision.
So, Jason, this case is really a matter of she says, and I wonder if you think there's enough hard evidence here to actually prove aggravated battery.
I do, Jamie, and the main reason is because of the testimony of the victim's treating physicians. It really doesn't matter what the prosecutor says or even the victim herself. It has to be verified, substantiated by credible scientific medical evidence. And all of three of her treating physicians came into court, testified that she has an injury causally related to blunt force trauma and that she has permanent injuries as a result of it. To me, it's very clear.
You know, it's interesting that you say that because I agree with you entirely, Jason, that what she says isn't terribly relevant. What the other she says isn't relevant really either, nor the prosecution's arguments or anything said in cross. But her doctors were not as conclusive as I'd like to see them be for proof of aggravated battery. Certainly maybe battery of a misdemeanor nature, but aggravated battery carries 15 years possibly.
No, I understand the concern there, Jamie, and that goes to the weight of the evidence, and that's the obligation of the jury to assess the weight of the evidence and then come to the conclusion whether or not they felt the prosecution met their burden by using the medical testimony. But let me just say something about closed brain injuries and closed head injuries, because I've represented clients with these injuries. They are sometimes very difficult to pin down through use of MRI and other type of diagnostic tests. When we have a broken arm, you throw an X-ray up and everyone can see that it's broken. Brain injuries just don't work that way.
Yes, and unfortunately for prosecutors, often you just can't make the proof, not because there's a failure in your case, but there may not be the science there to make the case. We'll talk more, Jason, about whether you think they can or they can't. We'll bring our other guest, Robert.
Well, she had her hair in a ponytail.
It don't matter. I grabbed her on the side of her head, sir.
Well, you're still holding your arms almost 2 feet apart. Nobody's that wide.
I put my arm, no. Can I demonstrate on you?
Sure.
All right, a little bit of a tangle in that courtroom. I'd say this defendant, Victoria Walker, is holding her own, but let's see what our guests have to say. Jason Friedman, prosecutor, Robert Bigelow, defense attorney. We've got both perspectives represented. So let's turn to our former prosecutor first. What do you think, Jason? It seems that she's giving your colleague there a run for his money on cross.
Oh, I would disagree with you, Jamie. I don't think she's doing herself any favors. There's a couple of main points. First, she's saying it was over as soon as it was started. It wasn't a fight. I mean, that's disingenuous at best. It flies in the face of all of the eyewitnesses. There was a fight. Now, there's some discrepancy about the details of the fight and what happened, but there was a fight, and witnesses on both sides said so. The second thing is she did threaten her. If you touch me again, every reasonable person would infer that that's a threat. There are repercussions if you do touch me again. And finally, she actually admitted to the simple battery. She said that she wanted to confront her when she grabbed her hair. And right there is an admission of guilt, at least of the simple battery. So I don't think she's helping herself out at all here.
Yeah, and I might agree with you on simple battery, but Robert Bigelow, what do you think? Jason, let me come over to you, because I agree with Robert Bigelow, though generally you can't put your client on the stand. You've got to when the defense is self-defense. From a prosecutor's point of view, when you're charging a case like this and you know that the defense will be self-defense, or you can kind of gauge that that might be where it goes, how do you make a decision question about how high to charge it, whether it be a misdemeanor assault or a felony assault. When you know what you're going to be up against, you maybe overcharge, thinking the jury will compromise down?
Yeah, I don't really think so. And in this case, I really think it comes down to the injuries. I think that was the deciding factor. I'm sure the prosecutor sat down with both the medical records, but then also spoke to her treating physicians, who we know came in to testify. And I think this is a case where she's admitted the battery. I think the self-defense is not panning out for her. Ultimately, the issue in the case is whether or not the injury rises to the level of a serious physical injury to substantiate the felony battery. So in this particular case, the decision, I think, really revolved around the medical evidence.
All right, medical evidence. Again, the science, if you will, the science. And, you know, Jason, I don't want to shatter not only your belief that these furry creatures are really people, usually teenagers dressed up, but I'm also going to shatter your view that the prosecution is necessarily doing the right thing here. Isn't Ms. Krause using this prosecutor and using this team and all of their hard work by exaggerating her injuries so that ultimately she can get some cash out of Disney?
No, Jamie, I disagree with that. First of all, she's not the one bringing the criminal prosecution. It's the people of the state of Florida versus this defendant. And if the prosecutors didn't feel that they were able to prove their case beyond a reasonable doubt, they would not be bringing this case. Plain and simple. So she is not the one dictating. The complaining witness is not the one dictating the prosecution here. And if indeed she did sustain a legitimate physical injury, she's entitled to compensation in the civil realm, primarily from the tortfeasor, from the person who assaulted her.
Well, then let me ask you another question, because we're all criminal defense attorneys, but we all also have to take that basic civil law course called torts. And in both areas of law, there's this notion of the independent actor. So let's just assume for a moment that Ms. Walker did something wrong, an assumption I hate to make on the best defense, but let's just assume it. How is Disney held responsible?
Right, and that's where the deep pockets come in. And it's a stretch to say that Disney is responsible. They're going to try to argue that there was a scuffle going on that the Disney employees knew about before it escalated to the point where there was physical injury, and that they had a duty and an obligation to prevent that little scuffle from escalating into a fight. I predict, however, the civil case against Disney is going to go by the wayside like the earlier one you alluded to.
All right. Well, with that in mind, we are still trying to get Ms. Walker on the phone, but with that in mind, let's take a quick look at a little bit more of her testimony as we wait for her to join us. And I love tangling with you, Jason. I hope I have a little more time in this segment to do it.